Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agenda's a disguise. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Good evening, everyone. Ooh, this is close. Let me move this back. My name is Pam Esquire, also known as Your Law Intellect. This lighting is so weird. What is going on here? Hope you guys had a fantastic Sunday. You guys know I've been under the weather, so I really was going to do this video, but I was like, whatever, we family. They didn't see me look pale before. It is what it is. Make sure you hit the like button. Subscribe to the channel if you have not done so already. You guys saw what the title was. Our boy Ernest Williams had another bad obstacle in his case. As you all know, he had a motion to suppress. We went to the hearings, had the video on part of it. And in that motion to suppress, the judge ruled, basically denied their motion to suppress. And that was the search of the vehicle when he was pulled over, which was Shirley Strawberry's, well, it was his truck and Shirley Strawberry's name is what's being alleged. And so once it was dismissed, the court put that they were doing an immediate, they were at the bottom of it. Let me see if I still got his thing. They were going to, they felt like the issue was of importance, that there should be a certificate of immediate review. And so what that means is that oftentimes, say for instance, in a lawsuit, the appellate court only has jurisdiction over certain types of, in certain instances. Let me take this off. They only have jurisdiction in certain instances. So typically you wait till final judgment, generally speaking, till the case is over. That's from the civil perspective and from the criminal perspective. However, in the criminal perspective, when you have certain issues that could potentially affect your case, you can ask the court to grant you permission to file an interlocutory appeal to go to the Court of Appeals, even though your case is not concluded. So in this case, the judge agreed that this was a situation or issue that warranted the immediate review of the Court of Appeals. Now the issue, I'm going to pull up what the rule is when you do an immediate, when you have this request. Now it looks like it's two prongs, but we're going to work this out together on what actually happened. What went wrong? We're going to help Ernest Williams out today and try to explain how this happened. So let me look at, hold on one second. Let me pull up the rule for appeals and the finality. Okay, so this is the actual statute, and it's appeals from the lower court's finality of judgment, effect of appeal, right? So this is under the Georgia statute, section 5-6-34, and we're specifically going to go to part B. When you go to part B, make sure you guys can still hear me, because I don't know why it turns off almost every time I do this. When you go to part B, it has where the trial judge in rendering an order, decision, or judgment not otherwise subject to direct appeal, including but not limited to the denial of a defendant's motion to recuse in a criminal case, certifies within 10 days. So the judge has to certify within 10 days of entry thereof that the order, decision, or judgment is of such importance to the case that immediate review should be had. The Supreme Court or the Court of Appeals may thereupon, in their respective discretions, permit an appeal to be taken from the order, decision, or judgment if application is made thereto within 10 days after such certificate is granted. So what it looks like from this statute, and again, I don't practice in Georgia, just reading the statute as it said, black and white. After a judge orders, they do their final order, like after Judge Dunaway said denied as far as the motion, within 10 days of that motion, that order, he is supposed to certify that it for immediate appeal. So within 10 days of that order, he was supposed to certify for immediate appeal. And then after that certification happens, the Ernesto or Earnest Williams and his crew, they will have to do a certificate for immediate appeal to the Court of Appeals. All right, y'all checking, y'all picking up what I'm putting down. All of this is going to make sense in a minute. So let's try to figure out what had happened here. So let's pull up the judge's first certificate, because remember, he did 2 certificates for immediate appeal. The first one he did was almost immediately after. Hold on. Is this the one? No, this is the January one. Let me go back. Hold on, y'all. I'm about to come down here. Let me find this. So this is the certificate of immediate appeal. This was September 30th of 2025. Now, the motion of Earnest Williams, a defendant in the above style case for suppressing the search of his vehicle, having been duly presented to the court on December 18th and August 11th, and said motion being denied on September 4th, it is hereby certified that. So according to this, it looks like he denied it on September 4th. And if I'm reading this statute correctly, that would mean by within 10 days. So I don't know if they give you the 10th day or not, but let's just say by the 13th, it seems like that certificate would have been in, or he would have said immediate, he would have did a certificate of immediate review. The decision and order denying defendant Earnest Williams' motion to suppress vehicle search is of such importance to this case that immediate review by an appellate court should be had. This was not even entered till September 30th of 2025. So y'all can tell me, intellects, about the statute. We just pulled the statute up. Does it sound like to you the judge was supposed to enter this certificate of immediate review and do this whole spiel right here before or on September 13th of 2025, but it didn't happen till the 30th. So he kind of started out, kind of wasn't going to work. So then on his new one that he did, because I'm assuming, okay, so remember, after this, Earnest Williams' team asked the court to basically reissue that same certificate so that they can, I guess, reissue the certificate so they can go ahead and file their certificate of application for appeal with the Court of Appeals. So the judge did that. And the judge did that on January 28th of 2026. And I believe Earnest Williams' team, they did get it in within 10 days. So they did get it in within 10 days of the immediate certificate of immediate review that was filed on January 28th of 2026. They did do that within 10 days. So let's see what the Court of Appeals said. Guys, needed that background so you know what's happening. Because I did see a comment about, yes, people do mess up a lot in the Court of Appeals because if you're not used to it, they do have certain rules. More so to me, federal Court of Appeals is more difficult than typical state Court of Appeals when you're appealing. But this was an issue of which the court is saying we don't even have jurisdiction. They only have jurisdiction under certain circumstances as provided in that statute. They don't just have jurisdiction over, you can just go file a case in the Court of Appeals. There has to be, typically, generally speaking, it's at the conclusion of everything and you have a final judgment, but there are certain circumstances where you need immediate review. Like, for instance, I had a case where it was election based and my client was going to run for election and there was some denials. And so I needed the Court of Appeals to immediately review it, because if not, you would just miss the whole ballot and it would be moot and it wouldn't matter. So there are certain instances where the Court of Appeals will hear it without it being a final judgment, as is listed in that Georgia statute. And this would have been the proper way to do it. But I'm assuming, based on the statute, unless I'm reading it wrong, that the timing was not right. The timing was off on when this immediate certificate for review came out. So yeah. I'm not helping. It already happened. Thank you, Patty, for the super chat. It already happened. I'm telling you, that's the judge. Like, what you mean? I'm trying to. Thank you for the super chat. Dang. Y'all, what you want me to do? Make it up or something? Jeez. All right. Let's pull up what the Court of Appeals had to say now that we have that long introduction. So here's what the Court of Appeals, and this was on February 19th of 2026. Earnest Williams versus the state. On September 4th, 2025, the trial court entered an order denying the motion to suppress filed by defendant Earnest Williams. On January 28th, 2026, the trial court certified its ruling for immediate review. Williams then filed his application for interlocutory review. However, a party may seek interlocutory review only if the trial court, quote, certifies within 10 days of entry and thereof that the order, decision, or judgment is of such importance to the case that immediate review should be had. And that's the statute we just looked at, OCGA section 5-6-34B. A timely certificate of immediate review is a jurisdictional requirement. And that's in Von Waldner v. Baldwin. I'd actually pulled up that case too. You know. So it's jurisdictional. So if it's jurisdictional, the court doesn't even have jurisdiction to hear it. So this is not, you didn't file the correct document. This is not, we want our caption a certain way. This is not, you didn't fill out some of them. I know in federal court, they may have like a filing sheet where you put a bunch of information on. They make you enter it in PDF. Like, it's not those type. There are a lot of tidbits that are required in appellate courts that are not required in lower court. So you do make some mistakes. And typically they have clerks. I know in the federal realm, they have clerks that are very, very helpful. Like, they don't just leave you out procedurally. But this ain't that. This is literally them saying, we don't have any jurisdiction. We won't have any jurisdiction over your case. We can't do nothing, sir. There's nothing we can do about this. So it says, if the certificate is not entered within the 10-day period, it is untimely, and the party seeking review generally must wait until final judgment to appeal. We lack jurisdiction here because the certificate of immediate review was entered well beyond the 10-day period. Therefore, this application is hereby dismissed. So what does this mean, folks? This means that when Ernest Williams goes to trial, that sounds like a movie. When Ernest Williams goes to trial, his attorneys can probably object to make sure they preserve it for the record. But this is the judge has already pretty much made the ruling. So all of this stuff is going to be entered in, or maybe perhaps it could be other reasons why, they may try not to have it. But I'm just generally speaking, this is going to be a part of the case. The stuff that he was trying not to have in the case, as far as the RICO, is going to be in the case. Now, what he can do, or what he probably will do once it's concluded, and if he is found guilty, he could probably attempt to appeal this again when the judgment is final. But how this affects his case is the jury will get to hear this. They will get to hear whatever evidence was gathered in the truck and everything that came from the truck. They will be able to hear that. If he was able to successfully, everything was timely, the application of appeal went through, he filed his brief, they did a briefing schedule, because I think he was on the May track. They did a briefing schedule, response, they had a hearing date, and he actually, the Court of Appeals agreed with him. He would have been in a better position, of which when he goes to court, then he can argue that all of this stuff that he alleges came from this search is supposed to be suppressed. And it wouldn't even be seen or heard by the jury. Now this stuff will be heard potentially by the jury. No, it doesn't look so. YouTube put the handles back, said, so it didn't matter that the judge tried to refile or reinstate their ruling or to restart the clock. The ruling was not reinstated. He's still the judge. If you actually look on his ruling, he still says the date that he entered in his original ruling. He didn't change that. So when you look on it, it's still, this is the old one, but it's still the same. It just changes. He says that the motion was denied on September 4th of 2025. So no, he couldn't take the order back and then say, well, I'm going to redo it myself, and redo the order that he already did. He was just reissuing the immediate certificate of appeal, which according to the Court of Appeals, I think I think what they are saying is they're reading this statute to say there are two steps. The judge has to file their certificate of immediate review within 10 days. And then once it's filed, say it's filed on the 13th, then Earnest Williams will have 10 days in order to file his application for appeal. So it's like it's two steps. Assuming that the reason why they asked for this again is because they missed the original 10 days. This is an assumption. I have no clue why they did it. Why they asked for it. I'm assuming that perhaps they thought that this would make it at where they can do it within 10 days again if he just reissued it again. Now, is this something that perhaps the lawyer has done before and that's why they thought they could do it again? I don't know. I don't know the circumstances behind it, but the way I'm reading it and the way the statute looks, it looks to me that there's actually a two-step process with the 10 days. That's what it's looking like to me. They gonna say the judge ain't do this. He didn't have to do it at all. You know what I'm saying? He wouldn't have had to do it. He could have said, I don't believe that it needs immediate review. I mean, he does. Well, I'm not gonna say that because then y'all be like, Pam, you always giving too much information. So I'm gonna leave that to myself. I ain't gonna say what I was about to say because I know some of y'all really be mad. So that is what happened. Make sure y'all hit this like button, okay? But that is what happened. I was actually trying to look at the law because I was like, this is interesting. Let me see. This case right here, this Baldwin case they mentioned, they said this was the Superior Court of Chatham County entered an order dismissing defendant's third-party complaint and denying motion to add third-party defendant as party defendant, and defendant attempted to appeal. The Court of Appeals held that orders dismissing third-party complaint and denying defendant's motion to add third-party defendant as party defendants were neither final nor appealable without certificate for immediate review, and that a certificate for immediate review, which was filed later than 10 days after entry of judgment appealed from, was ineffective to confer jurisdiction. So that sounds like it's the law. Let me find out. Hold on. The orders dismissed. So I'm reading from one of the cases cited by the Court of Appeals, Von Waldner v. Baldwin, Cheshire, Inc. And it has the orders dismissing the defendant's third-party complaint and denying his motion to add the third-party defendant as a party defendant were neither final nor appealable without a certificate for immediate review. And then it has all the case law supporting that. In Cook v. People, the Supreme Court of Georgia based its holding of the non-appealability, absent a certificate for immediate review, of an order dismissing a cross-complaint and refusing to make the cross-complaint defendant a party upon the provisions of the code, which includes claims, counterclaims, cross-claims, and third-party claims as the claims. Hold on, I'm trying to get to the meat of it. Okay, yeah, okay, here it is. In this case, what had happened was they said the certificate for immediate review, having been filed on July 3rd, 1974, which was later than the 10 days after the June 18th, 1974 entry of the judgments appealed from allowed under the code was ineffective to confer jurisdiction on this court to review the judgments. There's that. So yeah, that's their supports. Yeah, did y'all hit that like button? All of this extra crap when Wooten said fine, suppress it, I'm still ready to proceed. So what's next? No. Hoover is too busy. I heard he is now on that case with the teenager that unalived her parents allegedly. So Hoover's he was in like the gang unit, I believe is the unit he was in. So yeah, he deals with like complicated cases. So if you're going to get a person that needs a public defender, he would be the person you would get for a lot of these really high profile cases. Like that's what his specialty is. So yeah, he's gonna have a whole lot of these type cases. He should have the requisite help, I would surmise. But hey y'all, good to see you. Good to see you. Brother Will, won't he do it and said, let's go. He better off just going to, well, he don't have a choice now, Joy. He gotta go to trial. The Court of Appeals was like, no. This was not this. The rule says if you're gonna do a certificate of immediate review, you need to do it within 10 days. It was not done within 10 days. That means the Court of Appeals probably doesn't even know anything about the original one that was done back in September 30th. They probably don't even know about it. They go by the judgment. When the judgment was entered, when the court entered his judgment, his order and judgment denying his motion to suppress, that was September 4th. That is the date that they go by. So within 10 days of that, a certificate of immediate review should have been filed. And then the day, like say he filed it on the 13th, then by the 23rd, that means that Earnest Williams would have to do his application for appeal. It sounds like they did their 10 days. They did do their 10 days like they were supposed to after the court issued the immediate review. But if the court didn't do it, it sounds like within the right requisite amount of time, then it doesn't matter when Earnest Williams would have done it. So there's that. You said, okay, so now the appeal is kaput, and now and now the April court date is a final plea, and we start scheduling because I'm past ready to sit up in his trial stream and learn more about the shenanigans. Listen, I don't know what y'all think gonna happen. I'm kind of curious. Is there a plan? Is it because he has all of these cases now? Most of them, they're trying to merge them all together. Is he going to wait it out because they all got the same track? I don't know how this is going to work because it's a lot of cases. There's a lot of, he has like, what, 5 cases, 4 cases? Listen. Well, she's not going to talk about it on that phone call. None of those calls she's going to talk about this. Well, you know what it is. You know, I already told you. You know what I'm saying? The whatchamajigam, the whatchamacallem. You get me? Yeah, that's what I'm talking about. Yeah, that. Yeah, I told you, man. I told you Fulton County is so corrupt. They have a corrupt so and such and so and so. I told you that don't make no sense. Did you see that on the news where the guy, he ended up, you know, they say he stabbed his wife, and even though he had the knife in his hand and the blood was pouring out and they had 10 ring cameras, I don't even think he did it because, you know, Fulton County is just corrupt for no reason. They just be trying to take down these black men. I had 20 of my friends. They all went to Harvard University. They went to let me see what's that school? They went to Duke, and they all graduated cum laude, and they told me they don't understand why this case is still going on. It don't make no sense why this case is still happening. I don't know what is going on over there in Fulton County, but it's ridiculous. I'm going to get my investigator. My investigator is about to review everybody who is attached to this. Don't worry about it. I got you. I got you. I already called the Innocence Project. I already called about four. I called about 4 different law firms, and they said that your case will be a good case. So don't even worry about it. I got you. You get me? You get me? Because this don't even make no sense. Y'all know how it's gonna go. Y'all know how this conversation gonna go. Are they not releasing them anymore? I didn't know that. They're not releasing the calls, allegedly. Somebody, that's right, Ben Crump. Call my homeboy Ben Crump. That's their boy, Ben Crump. There. They said they need Ben Crump on the line for Nesto. Can you call him? That's your homeboy. You want to call him? I don't know. Deb said he busy. He just texted on me busy. You said, yes, they are. They just not talking as much. Yeah, they not talking to us. Nyla already called. He said no. Thank you, April, for the super chat. Super sticker. I appreciate it. No, I know. Yeah, I know Ben Crump. Well, I know. I ain't saying like I'm hanging out with him or something, but yeah, I know if I wanted to get contact with Ben Crump, I know how. You said the law office. Child, I thought I was gonna have to put some of that stuff on there from the Clarissa Shields fight on the Hood and Ghetto. Y'all see our Flint girl over here, huh? See her walking in? It's fight night. Y'all ain't know? Look at her in Papoose. Yeah, they had Little Caesars Arena selling Win Record sweatshirts, and yeah, she over there fighting down the street. You missed the Hood court. It's just so ghetto. That was funny. You know her well. Yeah, that's usually a Hood and Ghetto situation, what I just did. He said, who is better, Ben Crump versus Brian Steele? No comments. They don't do the same thing. Ben Crump does civil rights, and Brian Steele does criminal, and he's very good at what he does. Brian Steele is very good at what he does, and he's also a good appellate attorney, which some attorneys don't do both, and he's very good at doing both. Like I've seen him do a court of appeals case and a Supreme Court case in Georgia the same day, and he has some published opinions. Like that's like super dope when you could stand in front of a judge like, well, judge, they're like, where's your authority? Oh, State v. Smith, that was my case. That was a case that was mine. I'm using my own published opinion to support what I'm about to say and do in this court. And that's what Brian Steele does. So you can't take that from him because he's out here where his arguments and his appeals have become help to make the law. So Nesto can't afford a sheet of paper, let alone an attorney. Maybe he got some money hidden somewhere. Watch the Eldrick Foss trial. So I was over at Cat Not Williams' platform when the verdict came in, and everybody was like disappointed. I seen little snippets, and so I kind of gathered that that case was one where there was reasonable doubt and that he would probably get acquitted. And it sounds like everyone was surprised. And I think they've done like a GoFundMe or some type of fundraiser so that he can go ahead and file an appeal. So yeah, I am going to. I don't know how long the trial was, but I'll definitely get into it because I missed part of it. I saw little snippets, like I said, but I didn't watch the entirety of it to really have a full opinion. But I am going to watch it, especially if it seems like it's going to get to that point of appellate review, or even, well, he's probably going to do a motion for a new trial first. I hope that they go out and find, because it was an older case of what he was accused of. It was like a cold case. I hope they go out and they actually re-interview everyone themselves and also try to find new evidence and information, and that would make it that much stronger when they do trying to do a new trial. But yeah, you missed the verdict. Oh, it was terrible. Everybody was like really, really upset with the verdict. When I was over there, I was like, oh wow, the fight is getting ready to start. Okay. Pen pal, keep us updated. I should have put you in the membership so you could have let us watch it. Somebody is gonna be hold on. Kelly Price is singing right now. So Dejan, it's a couple of people that look like they streaming it. I might I'll find somebody's and maybe I'll just stream it in a membership because there's other people that are streaming it or whatever it looks like on live. They streaming it on their live, so I probably should have did that. Attorney Cruz will be interviewed tomorrow on a couple channels. Okay. Oh, cool. I'll go over there. What time? Do you know what time? I'm gonna go over to her channel then and watch. I like her. I like both of them. I like Melanie and Cat Not Williams. I remember I took a paralegal introduction course at my community college years ago. Is the work of a paralegal really that difficult? So just like with anything, if it's new to you, it seems difficult, but once you get the hang of it, it'll become routine. That's just like with anything from your mind, repetitiveness, it becomes natural for you. So to me personally, being trained by a lawyer on how, because every lawyer does things differently. And I was blessed that my first paralegal was just the bomb. Like we're still friends to this day. And she had been doing it for years and she didn't go to school for it. Back in the day, You just got trained by somebody and you learned how to do the work. And then just like anything else, people found out there was a lucrative for education. You can go ahead and make that a curriculum. So now it became, they have these classes, you can go for certifications and you can do this and do that. But back in the day, nobody was really certified. But when you have these big firms and you have it where it's oversaturated, of course, that's a good look on your resume, because you could say, I went to this school and accredited. But you learn how, just like lawyers learn how to practice law, when you get out here to practice the practice of law, that means we're consistently learning and consistently growing and building. So I'm still learning new things all the time, and I've been in it for a minute. But there are certain things that are just repetitive and routine for me because I've done it so much. And that's how it is with a paralegal. Like typically they do the same, and people intertwine paralegals and secretaries. But for the most part, with paralegals, they draft your documents. Most of the time you have templates for everything. So you got templates for your complaints, templates for your motions, templates for your discovery, templates for a lot of stuff, and they just plug the names in for a lot of the stuff. And they talk to clients. They can sit with clients and doing their discovery requests. So no, I wouldn't say it's that difficult, but I think with anything, when you don't know it until you learn it, yeah, it's going to come across like that. And it's very, I know some paralegals that get paid more than first year associates that pass the bar. And the reasoning is because they bring such an attribute to the firm. Like it was hard for me with other paralegals when I finally like broke away. I worked for somebody for like 2 years when I first came out, and then I went on my own. And when I had interns from law school, when I had other paralegals that came in, it was hard not to compare. Like I had a paralegal that did criminal law and I was doing civil law, so she was used to criminal. And it was just like after a while, a lot of stuff I just did it because I was like, oh my God, by the time I'm, whatever. So, but a lot of that was me because I didn't realize how much of a crutch I had with my paralegal who did a whole lot of stuff. And I didn't have to train her. But for the most part, when someone comes in, you train them to how you do things. So the course was like work. The teacher had us keep a binder that had to be a certain way and memorize a lot of things. So before, fun facts, I always wanted to be a lawyer, but I had a whole nother career before I became a lawyer, right? So I was doing something else totally different for 12 years. When I decided, I was like, well, I'm about to go be a paralegal because I was like, I don't got time to be going to law school. I got kids, I got a family. And so I went to school to be a paralegal is what I went to school for. So I know how they do it. Like they have you, with us, they had us like, you draft a complaint, you draft an answer, you draft all of this stuff. And then the instructor we had, she was working for like the city. So we used to do a lot of city-based stuff, would be like the templates that she gave. But I can't say that it helped me at all. Like, I'm not gonna lie. Like, I don't think it really helped me. But what happened is right before the school was for 2 years, I had done a year and a half. One day I literally was like, let me go take the LSAT. Oh, the LSAT is in whatever amount of time. I'm gonna fill out the application. I filled out the application. I went to the public library and I looked at the LSAT book. A lot of those, they have them at the library for you to study, but they're written in. They're literally written in, like in the books, but whatever. They still have them on the shelf, even though people done wrote in them and put their answers and what they thought it was and all of that. So I seen what it was about, studied a little bit, and I took the LSAT. And then the first time I took it, I got sick in the middle of it. So I left and went home. And they have it where as long as you say you want to delete your score before the score comes out, it's like it never happened. So they don't use it against you. But if you take it and you don't delete your score and you do a bad score and you take it again, they average your scores together. So I knew I jacked up because I got sick in the middle of it. So then I signed up. I came home. I was all distraught. I was like, I don't know. I was like straight up sick. I don't know if it was the pressure of it or whatever. Came home. I was all mad and evil and angry with everybody. And then I was like, okay, get it together. I deleted it, told them I didn't want to take, didn't want the score. And then I retook it again the next time, and I did pretty decent where it would get me in schools, but my undergrad wasn't all that. No, my undergrad, I didn't do my college undergrad like, ooh, I'm trying to get into a law school. So I had 2-3 schools that were like, okay, we'll go ahead and we'll take you in. And the first year, one school was like, it was a pilot program or something. And then another school was like, you'll almost come in on probation because of how my GPA was. It wasn't like just terrible, but it just was not like competitive. And then the third school, like school I went to, they was like, oh, we'll let you come in because of your LSAT score, and we're going to give you a partial scholarship. And you can start next month. I was like, okay. So I started like in 30 days. And then I went, so I never finished my paralegal program at all. I had 2 classes left in the paralegal program after I did all that and spent all that money. And I didn't go because they told me I could start that January, and I would have finished my last semester at the paralegal that same semester. So it was like, do I go to law school or do I finish what I started? And my professor was like, I understand you want to go, but you should finish what you started. I was like, I ain't gonna care about this paralegal stuff if I become a lawyer. So I was like, whatever. And I ended up going to law school. So that's my little story. And no, I wasn't in my 20s when I went. I had already been like literally doing something totally different in life. And so, yeah. Hello, Lisa in here. Hello, Lisa. Yeah, okay, Clarissa. Hold on one second. She bring Boosie coming out now. Oh, hold on.
Select luxury water, tough sheds, SMG Financial, and nothing but sports. Our main event is sanctioned by the WBC, the president, Mauricio Sulaiman, supervisor Frank Garza, by the WBA.
Striking my channel. All right, y'all. I'm gonna go. If you're in the membership, I'll go in the membership and watch this fight with y'all. Okay. But that's my story. That's what happened with Nesto. If you just coming in, pull the bar back because we done. I was just chit-chatting and answering questions. So if you're in the membership, I'm about to meet you over there in a second. But you'll be a good paralegal, Tracy. I told you that. All right, y'all. I'm gone. I'll talk to y'all later.